Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now state the Commonwealth of Massachusetts, court is open, please be seated.
Thank you very much, and good morning, everyone. Let me begin by introducing the panel to you. To my right is Justice Eric Neyman. To my left is Justice Andrew D'Angelo, and my name is Ariane Vuono. We have a full 6 cases on for today. We'll most likely take our break after the 4th case. It'll be a short break, about 15 minutes or so. I see everybody in here, I believe, has already argued before us, and so you know the rules. You each have 15 minutes to present your argument. We've read everything that you have provided to us, so you can get right to your most salient points as soon as you can. And just a reminder that there is no rebuttal in the appeals court. All right, with that said, I'm going to call the first case, Commonwealth versus Carlos Garcia-Parejo, 2023-1240. Counselor?
Good morning. May it please the Court, my name is Michael Warius. I represent the appellant in this case. This case comes before you from a bench trial. And at this bench trial, the judge chose to make statements about why he rendered the verdict that he rendered. And in those statements, the judge indicated that he relied on evidence that was not admitted. The evidence was the appearance of the physical appearance of the alleged victim. She was not part of this trial, but he knew her and had knowledge of her from a prior proceeding when she had a Fifth Amendment privilege issue and when her case was dismissed.
Counsel, if Ms. Soto had been sitting in the courtroom during the trial but wasn't called as a witness, would the judge have then been able to use that seeing her and made that difference regarding the physical characteristics?
No, because her identity was not in the evidence. If he had known who she was, and that she was Anna in this case, then that would be from information that he had personal knowledge of or gleaned from prior proceedings. That's what happened in this case, that he knew what her appearance was because he knew of her from the prior proceedings that had occurred when the Commonwealth dismissed the complaint against her.
Suppose she was sitting in the courtroom, excuse me, as Justice D'Angelo just said, and during opening statements, one of the parties happened to point to her in the courtroom.
I would say it's not evidence as well because the court is very clear in its instructions that openings and closings are not in evidence.
But the jury would presumably see the person.
Then I guess we would need a mistrial then because that would be inappropriate. And when I first started practicing, I remember reading the first transcript I had of a bench trial and being confused myself of what exactly are the protocols and the rules. Everything is very relaxed. But when they relax the rules for a bench trial, it doesn't relax the fact that the defendant has a right to due process. And certain considerations need to be undertaken. And in this case, making sure that you rely on a decision that's based on just the evidence is one of those things that's very important. And it's uncontroverted in the record. And my brother doesn't argue otherwise, that he made a decision that took into effect and it took into account the victim's appearance and was very much, I believe, persuaded by the difference in size between the parties. And I think the difference in size—
Let me interrupt you just for a moment. Did he really take it into account when we talk about what he actually found your client guilty of and the reasons why he rejected the self-defense?
I think he
In other words, didn't he make it pretty clear that what he was really relying on was that evidence that he believed showed that your client was the first aggressor and also evidence that showed your client could have retreated and did not, and so therefore self-defense was not available to him?
So the very first statement he makes is he says what I'm relying on. He says I'm relying on the testimony of the officers, and he says the respective size difference of the parties, and he lays that out.
Oh, I know he says that.
Right.
I know, but I'm talking about in
So he's
overall.
giving that as the basis for his conclusions that he's therefore going to find. He then finds the defendant not guilty of assault and battery with a dangerous weapon because a wall, he says, is not going to be a dangerous weapon. Now, he then moves on to the second count, which is this count, and he does state, that the conclusions about self-defense. But implicit in those conclusions is the size difference between the parties. Now, if I were to lunge at somebody—
Let me interrupt you. Help me out there. Why is that implicit? Because what would that have to do with the failure to retreat?
This case begins when And the self-defense claim begins when Anna gets up in his face. She moves at him. If I were to move quickly at Judge D'Angelo, for instance, the court officer may jump in. The size difference between the parties here was relevant to the judge's consideration of the type of force that needed to be used for self-defense. Now, when she got in his face, that's when he makes the first push away with a pillow. Then the fight begins to escalate greater. She hits him with a Sprite bottle, he pushes her back again with a pillow, and he says he punches him, and he gets out of the room. So from that moment, we have to look at that first moment when this began to escalate from a purely verbal argument, that she gets up into his face and he pushes her away with a pillow. If she were to be, the same size as him or larger than him, perhaps the court would have said that that action enough was showing that he was acting in good self-defense because he had a legitimate fear for his safety. And with this case, the way it was tried, counsel didn't have the opportunity.
But self-defense requires more than just a fear of your personal safety, right?
Well, I would argue that when she's up in his face, that he had a fear that she was going to put him, into some jeopardy and maybe hit him. And if the size difference was going to factor in, counsel lost the ability to introduce other evidence or even call his client as a witness as to his feelings about what was going to occur and what actually happened in respect to the party sizes and strengths and those issues. But that was taken away from counsel because the evidence closed, and this issue was first raised after statements were made by the defense attorney during closing argument about self-defense.
You're saying that the judge's statement, it's a finding of fact that you're saying is clearly erroneous because it's not supported by the record. Is that correct?
That's correct. It's a basis for his decision.
So when there is an error in a finding of fact, that is a clear error in finding of fact, we then go on to do a prejudice analysis, correct? That's what the law dictates?
I think for a finding of fact, that's correct. But I think for this type of error, this court's unpublished decision in Hollins is a little bit different. I think Hollins is saying when you...
Can you point us to, I'm aware of that case, but what can you point us to that is published, that is precedent in terms of our standard here?
Well, I think in our Commonwealth, there is not a published case that's on point with this issue. I think that this court's decision, though, in, I think, Commonwealth versus Hollins, is on point where it says that because they're unable to infer on this record that the judge decided the case on a permissible ground as opposed to erroneous grounds. So if one of the grounds for...
I'm sorry to interrupt you, but that's sort of, this gets back to Justice Vuono's question, which is, we've seen this before, where a judge makes a finding of fact that is clear error, and then we still conduct a prejudice analysis. We see what else is in the record. So, for example, if a judge made a determination on the basis of, for the sake of argument, my hypothetical is not this case, but if a judge makes a determination based on 15 findings of fact, one of them is clear error, we still often go on in the analysis to determine whether or not that error was so prejudicial as to warrant reversal, as to show that there was not a fair trial or an appropriate consideration of all of the factors. And here, as Justice Vuono pointed out, the judge did make findings that the defendant was in fact the initial aggressor, that he did in fact push the pillow, that he did in fact start the argument, and that there were better means available to him such that self-defense did not apply. So help us out here. What are we to do in terms of weighing this? Is it just a standard prejudice analysis? Which it strikes me it likely is, but I'm looking for guidance.
I mean, it is under the prejudicial error standard, but to pull apart the judge's findings from the basis that he stated for his findings is impossible. That in this case, the judge did not clearly delineate what he considered in making his findings on each of those points.
If that's the case, then any time a judge made a finding of fact that was clear error, then we could always make that argument and say, we just don't know. I mean, unless the judge were to put in his or her findings a percentage that they gave us to each particular finding of fact. So that, I'm not seeing how that argument passes muster.
I think in arguing clear error comes up a lot, right, in suppression issues. And this is a different beast of a trial. So if this court, for instance, were to say we can't be devoid, we want to send it back for further findings by the judge, I mean, I don't think that works in this type of case where there's been a trial. Now, that may work in a suppression issue to send it back and say that we need further findings in order to, have a proper order. But in this case, that's not really what it is. I mean, the judge could have rendered a verdict without making any statements, but we have the benefit of the statements that he made. So he felt that these statements were important enough that he said exactly what he believed his decision was based upon.
So then my follow-up to you is this. If a judge makes a finding of fact after trial, and that finding is based on something that was not admitted as evidence in the trial, you are arguing then that as a matter of law, it always requires a new trial.
I think there's a way that, certain...
The judge said, I rely on the following 20 findings in rendering my verdict, and one of them is not supported by the record, as in this case. Are you saying that invariably mandates reversal?
I think it depends if the basis for those particular findings is the thing that was not in evidence. I think here it's very clear that the size of the parties was involved in each of those findings. And he's not clear that it wasn't involved in each of those findings. I think there may be situations where certain pieces of finding maybe are not implicated in certain decisions that he makes. But here, these are very much interconnected. So I don't think there's a need for an overarching rule that, that this is a per se error. But I think there is a need here when you look at those key areas, they're all impacted by the size of the parties here.
Counsel, when a judge or a jury goes on a view, is that considered evidence in a case? I always remember, and I could be wrong, that there's an instruction that's given that it's not really evidence, but it's something that the parties can use later on.
Right.
And I'm trying to figure out, would it have been appropriate here for the Commonwealth, and I hate to use this language, it's a woman, it's Ms. Soto, could they have asked the judge to take a view of Ms. Soto if she was in the courtroom? That would have been appropriate, right? It's not testimonial to say, look at the size of her.
It may have been appropriate. I mean, it's not something I considered. But I think that being that she's the victim in the case, that they could have presented her in some way. I think counsel may have, asked for a different way to have her identity presented, and probably, they would have come up with something different, I guess, to get around the Fifth Amendment privilege issue in this case.
So the error is that if it's error, is the Commonwealth didn't do that. So that was not evidence. Even though the judge saw her, the judge observed her size, that was the error. It was the Commonwealth didn't say, hey, Judge, we're going to ask you to remember what you just saw and consider that as a view. That's the problem.
And in doing it in some way like that, it gives the defense counsel an opportunity while the record's still open, right, to make challenges, to object, to then, if it does get into evidence, to present a defense that takes into account now the size of the parties, where in this case, the size of the parties was not made an issue until during the closing argument when the judge started to question the defense counsel about the size of the parties. And so is that something that I could consider? The judge wasn't sure if he could consider it initially, it seemed. He said something I consider, and defense counsel said I would say you should stick with what was in the evidence. And he's, well, I think it's fair. I think it's fair for me to consider it, And then they kind of move on, and counsel tries to deal with that error as best he can. But
counsel have objected when the judge made that type of comment of, well, I think it's a fair thing for me to consider?
I think that in hindsight, having a formal objection word would be nice to have in the record, though, as I do argue here, I don't think it was necessary. And I think in the fact we have the relaxed setting of a bench trial, that it was more of a free-flowing conversation where he says he's going to consider it, counsel says, I want you to consider it as limited to what's in the evidence, and then the judge moves on and says, well, I think it's fair game. At that point, the judge has made a decision. So counsel moves on and makes an argument about now taking into account the size of the parties now being part of the record under his belief. Would it have been nice for me if counsel would have made an objection? Certainly. And I think that
Before
would be a
your
better.
time is up, again, I
Thank you,
apologize for interrupting you. Before your time is up, I just want to clarify one thing. I'm assuming you would agree that when the judge conducts a colloquy with the victim in this case, who takes it and agrees that she has a Fifth Amendment right and says you validly invoked it, those proceedings are part of this trial,
They're in the record, yes.
right? Excuse me?
They're in the record, yes.
Yes. Okay.
But it was done before the trial was
I know
actually
that. That's why I
impaneled, and-
I just want to make sure that you.
Yeah, it was
were
kind of done in
agreement.
limine, I guess, in this case,
Yeah.
right?
Yeah. Well, of course, the cases were called together but the case involving your client was definitely called, and then the Fifth Amendment invocation was you agree was part of, it was something the judge conducted as part of this trial, not as part of some other trial, i.e.
Correct, yeah.
the one that was
It
dismissed.
was part of the.
Exactly.
Before the bench trial actually started, it was in the.
Exactly. All right.
Limine phase,
Just
yes.
want to make sure we agree about that. Thank you.
Correct. Thank you.
Well, I'll just see if anyone has any further questions. No, thank you very much.
Thank you. May it please the Court. Patrick Cespedes for Middlesex on behalf of the Commonwealth. The defendant's own admissions provide uncontroverted evidence of an assault and battery in this case. He escalated a strictly verbal disagreement into a physical confrontation when he pushed the victim, which was an offensive and intentional touching. By the same token, there is no credible basis in the record to support a claim of self-defense where the defendant was found to be the first aggressor and that he had the opportunity to retreat but failed to do so.
You know, we'll see whether or not the panel agrees with you, but the million-dollar question here is, can the judge do what defense counsel alleges happened here? Take into account his observations in the courtroom. Do you have a case that says he can?
So, Your Honor, yes, and it's in large part because this was a bench trial. So we know that the judge could take account of the defendant's size. That comes from cases, plenty of cases that say you can consider the defendant's size. He's sitting at counsel table. He's there for the taking of evidence. The victim is a closer question, but it's significant that the judge conducted a Fifth Amendment colloquy in this case. Had the judge conducted the colloquy in the middle of the trial as opposed to 5 minutes before it started, there's no question he would have been able to consider the witness's physical characteristics.
Why? Why is there no question about that? Because a bench trial is virtually the same as a jury trial. He is the fact finder, in this case he, as opposed to the jury. If there had been a Fifth Amendment privilege question in a jury trial, that would not have been done in front of a jury.
What would have been done, though, and often it sometimes happens, is the witness is called to the stand by name, gets up, walks to the stand, the jury is put back into the jury room, and the Fifth Amendment colloquy is conducted.
Really? Do you have a case that that's the appropriate mechanism, that a witness is actually called to the witness stand and the jury sent out before the colloquy is done?
So I don't have a specific case at the appellate level. I know that's happened in jury trials conducted by our office, and in that case, when the witness stands up and makes his way to the witness stand, that is fair game. You can consider that witness's physical appearance.
But that didn't happen here at trial.
No, and so that takes me to the next point of bench trials being more relaxed than jury trials.
More relaxed, but what case says that evidentiary considerations are different at a bench trial than in a jury trial?
So I think one key case is Bonner.
Our rules of evidence are different at bench trials than jury trials. That's my question.
To an extent. So first, C. Sangret says that judges can consider in bench trials evidence that may be unduly prejudicial if in front of a jury. So you have these relaxed standards, but cases like...
Wait. I want to make sure we're not misstating something.
Sure.
Those cases that say that, it's because a judge in a bench trial is assumed to instruct him or herself to disregard certain evidence if it's overly prejudicial, if it comes in. So in this case, the judge can consider something that would otherwise be disregarded in front of the jury? What case, again, back to Justice Neyman's question, says it's that relaxed?
So Bonner, cited in our brief, says that deviations from usual procedure rarely are prejudicial. And I understand that's a prejudicial analysis. So I think in this case, There are several ways to find for the Commonwealth. And again, I think our strongest argument is prejudice, so I don't want that to be mistaken. But I think it's possible for this court to hold in a very narrow way that because the judge conducted a Fifth Amendment colloquy immediately before the trial began and could have done so during the trial, given the flexible nature of bench trials, it was proper to consider the victim's relative size, especially where the judge gave the parties a chance to contest this factual determination.
I want to go back to something you said
Yes.
a little earlier. So you're suggesting that in front of a jury, a party can call a witness. The witness can walk in front of the jury. Ultimately, the jury gets sent out. A Fifth Amendment privilege is asserted. And then a lawyer can then say, hey, do you remember that witness that you saw come up to the witness stand but never testified? Look at what she looked like. Look at her size. You think that's appropriate?
I do. I think once a witness stands up in front of the jury, even if
Well,
it's
this person's
unspoken.
not a witness. This person doesn't testify.
Right, but again, I think it's very
Person
simple.
has a Fifth Amendment right, so
Yes, and I can imagine a scenario where the witness does not want to assert until halfway through their testimony, or situations like that where the jury is not precluded from considering simple physical characteristics.
That didn't happen here.
Right.
So let's get back to that. Your last statement was that you want us to carve out a rule that says that evidence that could have been presented to the jury but wasn't, or rather here to the judge as fact finder, but was not presented, should ultimately be considered
In a bench trial
calculus?
as opposed to a jury
Give me
trial.
any legal authority for that.
Just the usual deviations from usual procedure are rarely prejudicial. I don't think it's too far of a leap to say the judge was not required to bring the witness, bring the victim
Give me a case
in.
that stands for the proposition that in a bench trial, hypothetical evidence that could have been admitted but was not may be considered by the finder of fact.
I think that in a bench trial, it would be an empty exercise for the judge to reopen evidence, say, victim, could you please stand up in the courtroom? I'm taking, I'm going to consider her
Victim
size.
in the courtroom?
Yes, victim
Transcript
was.
reflects that?
Yes, it is in the record. The victim was in the courtroom, stayed for the entirety of the trial, which is why the judge, in talking about the relative sizes of the parties, said, she's been before me for about an hour, and that was the length of the trial. So we know she was there in the audience. And in that case, like I said, it would be an empty exercise to have her come to the witness stand or stand up in the audience and to just physically observe her. It was much easier to say, defense counsel, can I consider this? And it sort of went from there. But
Give us your very best case for that legal proposition.
So I would say two. I would say cases akin to Sisangrit and cases akin to Bonner, both of which are cited in the Commonwealth's brief. But taking it back to the prejudice prong, that is by far the strongest case. Not only was it not considered for the parties' relative sizes was not considered for the A and B charge, it was only considered as to the ABDW charge for which the defendant was acquitted. So there could not have been any prejudice. And that comes from cases like Duffy, 62 Mass App Court 921, that says the admission of evidence, even if error, is non-prejudicial if it directly relates to a charge on which the defendant was acquitted.
Wasn't it the same act, in a sense?
No, Your Honor. There's two different acts here. So the first act is when the defendant picked up a pillow and pushed the victim, ostensibly to create distance. The next act is after the victim throws a Sprite bottle at his back, the defendant turns back around, picks up the pillow again, and punches her through the pillow, causing her to fall and hit her head on the wall. So these two distinct acts are served for the bases for the two charges. The A and B, the simple A and B.
Dangerous weapon is the wall, not the pillow, correct?
Correct. The dangerous weapon is the wall, which the judge did not go for. But the simple A and B is the pillow push. The ABDW is the pillow punch. And so we know these two separate acts, the evidence, the parties' relative sizes were only considered for the ABDW. And that comes from the transcript pages 65, 69, and 73, taken together. If there are no further questions, Commonwealth will rest on its brief.
Any further questions? No further questions. Thank you both very much.
Thank you.
All right, our next case is case number 2023-0193, Commonwealth versus Alberto de Exposito. Good morning.
Good morning. May it please the Court, my name is Attorney Carl Suchecki. I represent Mr. Alberto Exposito on his appeal. There are two different issues we briefed in this matter, the first of which is a variance between the indictments and the bill of particulars and what was adduced at trial. The complainant in this matter, when she testified, actually testified that the events occurred 2 years earlier than the indictments and the bill of particulars laid out. And it was trial counsel's position that he was prejudiced thereby because he had hired an investigator, and this case had gone and had been in the courts for 4 years, and there's no change in those dates until the time of trial when the complainant testified and changed those dates. When the prosecutor was asked about what they said about the bill of particulars, they said they didn't know what the complaint was going to say until she testified at trial. It's our contention that because there is a variance between the bill of particulars and the indictments and what was testified at trial, Mr. Exposito was prejudiced thereby because he wasn't given the opportunity to adequately investigate and get an alibi. And essentially, if the defendant does not have the dates of a sexual abuse or a sexual contention, then there's no way that he has a proper way to appear, produce an alibi. Now, I understand it's not an element of the sexual case, but at the same time, in the sense of due process, that the defendant is entitled to present a defense, and if the
I'm sorry to interrupt. Are you arguing due process under the state and federal constitution?
Yes, Your Honor.
Are you arguing that there's any distinction in this context between the two?
Not that I remember, Your Honor. But just in the sense of, I understand it's not part of the elements, but just as a fairness for, presenting a defense, the defense should procedurally be allowed to investigate. And if it...
Counsel didn't bring any of that up to the judge as far as the timing hurting his defense in the sense of asking for a continuance to see if there was anything he could do. What do we make of that?
Well, what we make of it is this didn't come up until the very end, when the Commonwealth actually tried to file an amendment to the bill of particulars and indictments to essentially after closing arguments, after he had filed a motion for required finding.
Didn't it come up during, the witness testified, and it was clear during the direct and cross-examination exchange that the timing was different than what the indictment said.
Correct.
And he, at that point, still didn't bring it up to the judge of, wait a second, I need time to investigate this. Or that was
No, he did not. He did not.
So part of your argument, as I understand it, is because of the variance, the defendant was deprived of raising another defense, in particular an alibi.
Yes, Your Honor.
The defendant could have filed a motion for new trial, for example, and created a record. So, for example, your client could have filed a motion, had affidavits that said, during this time period, I was living in France and could not have possibly committed these crimes. And then we'd have a record on which to make that determination, as opposed to it being speculative or a possibility. So what do we do with the record before us?
Well, in essence, I think that the argument that trial counsel made post-amendment, attempt to amend it, was essentially was his motion for required finding of not guilty. And if the Commonwealth doesn't present the evidence that they said that they're going to present, that occurred during a particular time period, it is up to the court for the judge to have a new trial based on the fact that the Commonwealth didn't present their case.
But under a required finding, didn't the Commonwealth satisfy that? So I'm looking at the trial transcript, volume 1, page 19, and granted, it was in response to the prosecutor's question setting the date, but the prosecutor asked the victim to testify to events that occurred in 2017. And that's what was testified to. And then on cross-examination, there was testimony that this occurred when the victim was 7 or 8 years old.
Right.
So is that really a variance, or is that just a distinction, or rather an inconsistency in testimony that is to be explored on cross-examination, as was done here by counsel?
Our argument would be that it's a variance, and that in this case there should be a new trial based on the fact that he prepared for a trial for 4 years, and it wasn't until the date and the actual testimony of the complainant that the time shifted, and thereby he didn't get a chance to adequately investigate his case.
Is your argument any different if there hadn't been a request for a variance or an amendment? So they go forward, the indictment says 2017, on direct she testifies to 2017, but then as Justice Neyman just pointed out on cross, there seems to be a problem because of what her age is. What if the case had just gone in that way? Isn't your argument exactly the same, that you weren't on proper notice, you don't know when the crime actually occurred?
Perhaps, except for the fact that with the tacit acknowledgement by the Commonwealth changes it. It's essentially an admission that they didn't present the case that they said that they would present. So the bill in particular said a particular time period, and the indictment said a particular time period, and the Commonwealth obviously realized it after the fact, essentially after the trial, and tried to amend it. And our contention is that's a tacit admission that they didn't present the testimony that they said they would, or that the indictments in the bill in particular said was going to be presented.
But the judge didn't rule on those, correct? Didn't he?
Sorry?
The judge did not rule on
No,
those.
he made no finding on this.
So how do we know what the judge, because this was jury waived.
It was.
How do we know what the judge found the defendant guilty of? Was he guilty of the indictment where it said 2017, or was he guilty of when she was 7 or 8? How do we?
As just like trying to read the minds of our jurors, there's no way of knowing what the judge, what he based it on.
Acknowledging that you were not trial counsel, was this issue properly preserved? Because my understanding is that the objection was to the motion to amend the bill of particulars.
Correct.
And the judge took no action on it, and defense counsel said fine. So is our correct standard of review here substantial risk of a miscarriage of justice? Would you agree with that?
I read the standard, and I did read that, and that is problematic. I'm not ready to say that, except for the fact that that is the standard that I came across as well. I think it might even reach that high standard in the sense that a defendant has a right to present.
I'm not asking if it meets it or not. I'm asking,
yeah.
Is that our correct standard of review on this case?
I'd leave that for you to decide. Our answer would be
Well, we will decide.
Yes,
that,
I know.
I'm certainly seeking your guidance. we do get to ask questions on occasion.
Your Honor, and I'm doing the best I can with the questions you ask. The second issue we had to brief today was the fact that there's an indictment for indecent A and B for a touching of the complainant's vagina during a game that they played, and the indictment read a certain way, the bill of particulars read a certain way, the Commonwealth presented during opening a certain way, that was going to be the evidence at trial. When asked specifically during questioning, the complainant said that when the prosecutor in every way possible tried to lead her to say that she was touched on her vagina, and she said absolutely no, and that's unequivocal. And it's our contention, since that is unequivocal in the record, that the judge had no basis for ruling that in fact occurred, that there was an indecent A and B of touching of the vagina, and therefore that count should be vacated.
Okay.
So if there's no other questions, we'll rest in our brief. Thank you, Your Honor.
Thank you.
Thank you.
Good morning. May it please the Court. Assistant District Attorney Lee Baker for the Commonwealth. I guess that I could summarize the Commonwealth's position with regard to both claims with one sentence, no prejudice. As regards to the first claim, that the date was changed mid-trial, this is not a case where in the middle of the trial or on the eve of trial, the Commonwealth suddenly discloses that the assault occurred at a different time or in a different location. This variance about the date occurred in a very organic manner through examination of the witness. I think it's important to bear in mind that this is a 13-year-old witness who's being asked to testify as to dates and time periods. And in my brief, I did look at each of the times in which she gave ambiguous testimony about dates and broke it down. You could see that internally it doesn't make sense, that she's just simply wrong. She's not doing something nefarious. She's not trying to change the case. The prosecutor has no role in this other than to try and rehabilitate the witness. And ultimately, there was no prejudice to the defendant from this variance, and in fact, it was beneficial to him. The judge did not take action on the motion to amend and specifically said, with regards to that he would consider that when he weighed the credibility of the witness, which I would suggest that he did, because he did acquit on some counts. So
I guess I'll ask you the same question that I asked opposing counsel. We don't know when the judge found, beyond a reasonable doubt, that this child was inappropriately touched and raped, right?
Right.
So how is if we don't know, how is the defendant on proper notice during the trial of like an alibi? It's just sort of extremely amorphous in this case.
Sure. And there's certainly circumstances different from this in which it would be prejudicial to the defendant. But this is very fact-specific. The variance in the dates going from 2017 to 2016 doesn't change the uncontroverted testimony that the defendant had access to that child in all of those time periods. And in fact, the defense was that it just didn't happen. It wasn't that I was somewhere else or anything like that. Because we know from the record that the defendant was residing with the victim during all of those relevant periods, there's no surprise there. There was nothing developed in the record to suggest that he would have been
To Attorney Suchecki's point, though,
Sure.
you know, defense counsel's been preparing this case based upon his client's alleged involvement and whereabouts on particular dates and particular year.
Right.
I mean, what's the point of mandating the Commonwealth to file a bill of particulars?
Yes.
And then midway through a trial, that bill of particulars is meaningless. It's wrong.
Right. Well, I wouldn't say it's meaningless. I would say that the dates, because they don't go to the elements of the offense, are not given the same kind of weight. But I do want to concede that there would be situations in which this would be prejudicial to a defendant, but this is not that situation. As far as the alibi defense goes, it's not simply the case that he didn't say at trial, well, Your Honor, I would like a continuance. I would like the opportunity to investigate this. Trial counsel filed a 25B motion to set aside the verdict, and we had a hearing on that, and I appeared for the Commonwealth at that hearing. Now, at that hearing, I argued that if he had in fact been prejudiced by his inability to develop an alibi, here was his opportunity.
You mean under the 25B2 motion?
Well, that now he could develop that, submit a Rule 30 motion for new trial with an affidavit in support of that.
And there was no Rule 30 filed here.
Right. And so the judge actually stated at the end of the hearing, explicitly on the record, I'm going to give both parties another week to file anything that you want me to consider on this, after that issue had been raised. And nothing was filed subsequently. And so there's no real live issue here of an alibi, just on the facts that are on the trial record. There's no reason to suspect that there is any possibility of developing an alibi, because we already know from the trial record he's in the house. And his whole defense is this didn't happen. So there is just simply no prejudice to him. It's not to suggest that this, in every case, this would be acceptable. But this is a case in which it was in no way initiated by the Commonwealth. It was ambiguity in testimony that I would frankly say is commonplace in cases like this, with young witnesses like this. And the judge acted appropriately, and defense counsel acted appropriately as this unfolded. Defense counsel didn't object. He exploited it on cross-examination. And he did it again and again. Over and over again, he set this witness off her balance, got her confused about the dates, and made her seem less credible. So it's really hard to see, other than in a highly formalistic way, how this could in any way be detrimental to the defendant.
What do you say the standard of review is in this case?
I said it in my brief.
Otherwise said, was this issue properly preserved or not?
It was not. There was no objection. And so the standard is substantial risk.
Can I ask you about the objection? Because you did mention that a few times in your brief, that there was no objection during the witness's testimony.
Right.
I'm curious, what type of objection was supposed to be made during the witness's testimony? Objection, she's lying? Objection, she's what? It's not a proper objection, is there?
Right.
So how could he have objected if there was no proper objection to be made?
Right. And he didn't object because there was no objection to be made, because there was nothing objectionable about the testimony.
Well, couldn't he have objected after the testimony and said, I object and I move to strike the testimony because it is a fundamental tenet of criminal law that you must charge a crime as proved and prove as charged, and there is no testimony from this witness regarding the time indicated in the indictments or in the complaint?
I suppose he could have made that objection.
Could have been an objection and a motion to strike, couldn't it?
He could have made that objection. I just look at this realistically, trying these cases and I've tried them as a defense attorney, and I would be surprised at a defense attorney that objected to that.
Certainly during the testimony, yes.
Right.
I guess your point is just because you made the point that that testimony, in your view, was beneficial to the defense.
Indeed.
Okay.
If there are no other questions, I'd
Well, let's
rest
check
on
with the
my...
panel, and I see no further questions. Thank you both very much.
Thank you.
Okay. We'll move on now to our third criminal case in the morning. Case number 2023-1380. The parties here? Yep. Commonwealth versus Gerard F. St. Martin.
Good morning. Charlie Yellen for Mr. St. Martin.
Good morning.
And Your Honors, affirming the conviction would set an unruly and I think unjust precedent, and here's why. To adopt the Commonwealth's position that the defendant's actions, awful as they were were inherently reckless would be a broad reading of the statute sweeping into its scope a large number of future cases that would effectively escape defining recklessly. Far better to narrow the category inherently reckless to those cases where there's a near certainty of harm, just like all the cases cited by the Commonwealth. Anytime you have a category modified by the word inherently, it's going to naturally narrow the scope, and such should be the case here if you examine the facts closely. It's 3 a.m. The girls are sleeping in a darkened room, and whatever noise the defendant's making, it only wakes up one of the girls. These are factors that mitigate the risk. They lower the risk that harm will occur. It may have been reckless. It's not inherently reckless. Send this case to the jury. I'm not arguing Lattimore here. Send this case to the jury with the proper tools and explanations to understand an uncertain legal term, recklessly. There are volumes written of law review articles, I think, on exactly what this word means. Let's give the jury a hand here. The facts are odious. I would say they're inherently disturbing. That goes to the elements of shock and alarm, not recklessness. But given the facts and human nature, I think a jury is going to be naturally inclined toward conviction. That's why.
I'm sorry to interrupt, was recklessness at issue here, or was this an all-or-nothing defense? I think the defense was, this never happened. So I'm not sure that, was mens rea an active, live issue at trial? I understand it's an element, but was it a live issue?
No, okay. It really wasn't. Of course, as you said, basically the theory was that, as my sister said, that the victim lied. But the jury still has to find guilt beyond a reasonable doubt on each of the elements. The judge instructed the jury, of course, to that. Counsel reminded the jury of that in closing argument. And the only element, if the jury's focused on the elements of the crime, the only element they could have struggled with, and they struggled. They couldn't find quickly a unanimous verdict. The only element they could have struggled with was the third element, dealing with recklessly. Why? Because the other elements were easily satisfied. Did he expose himself? Yeah. Could this be shock or alarm? Yeah. Only recklessness. So,
except that's not what the jury was being focused on by manner of the defense. The defense was it didn't happen.
That's exactly right. They still had to find guilt beyond a reasonable doubt. The judge didn't say only focus on what counsel's defense was. And I don't know why he didn't raise it in closing argument, or more so during the trial. He certainly raised it. The judge knew about it. The judge knew about this from the directed verdict stage. He raised this issue of whether it was an open incident. He said he focused on the fact that they were sleeping. Why he dropped it, I don't know.
And your argument is that the model instruction that was given, which is the district court model instruction, is not enough. There should have been a supplemental instruction further defining reckless other than just using the word, correct?
Yes, and I'm working off of Kessler. And I understand, and I agree what Kessler says is dicta. Don't throw this dicta under the bus so quickly. The court took some pain to discuss defining the need to discuss defining recklessly. It said, the court in Kessler said this was important. The court in Kessler meant for us to use it as a guide. you might ask, where is Kessler cited for this in the future, subsequent to Kessler? It's not. It's not cited. Neither are there any cases where, similar to this, where the risks are mitigated and Kessler isn't used. This is the case for Kessler.
But in Kessler, mens rea was at issue at the trial, correct? The defendant, I believe, in that case was in his house masturbating like by a window or behind a curtain.
Yes.
And people from outside saw him. So the issue was that conduct open and reckless within the meaning of the statute? It wasn't an all or nothing case like this one.
Yes, but I want to just speak to one thing you just said. I don't believe there was any mention of a curtain. It's daylight. It's daylight. It's a window. You see through the window. He waves the children over to the window. He jingles his keys. He waves them with his hand. They're 20 feet away. If recklessly needs to be defined in Kessler, it certainly needs to be defined here.
In what instruction would you have a judge give? How would you have a judge define recklessness?
Well, I know that, I think in Kessler, it says that, recklessness requires more than a showing than someone might see the defendant. I would use some variation of that, plus all of, there's cases for all different crimes when recklessness is defined as highly likely to cause the harm, substantially likely, probably far more than negligence, some combination of that. I mean, the risk here of a substantial risk of miscarriage of justice sits because the dictionary definition of recklessly is not what the legal definition is. If the jury is going to use a dictionary definition, common usage, careless, that swings the door wide open to a substantial risk. And I recognize, as I said, that the facts are odious, but that goes to another element, and we need to divorce the elements when we're thinking about this case. If there are no further questions, I'll rest.
No further questions. Thank you very much
you.
for your argument.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. The standard of review here is substantial risk of a miscarriage of justice, and not just because there was no objection, but the defense actually stated affirmatively the defense is satisfied. This wasn't a situation where the defense was arguing this issue. He attacked the victim's credibility with some force, both in his cross-examination and closing, and he was saying this didn't happen. And if it did happen, the elements are met. Essentially, he used stronger language than that, which is quoted in my brief, but essentially he did this all or nothing. And so in the circumstances of this case, the Commonwealth is suggesting that if it was required to have the recklessly element defined, which is not part of the model instruction, there's no substantial risk here because the defendant's conduct was just so not just negligent, not an accident. It was inherently reckless. And so this is not a situation where an element was misstated or omitted with its entirety. The judge gave the instruction on reckless. He said this was for the intent required for exposure, intentional exposure or reckless disregard recklessly disregarded a substantial risk that a person who would be offended would see him, would see the exposure.
Under Kessler, should the judge have given a supplemental instruction regarding recklessness?
I don't think so in this case. I think Kessler is distinguishable from this case because Kessler's inside his home and people are looking into his home. And the home is owned by his mother. And so, as I said in my brief, it was dicta. The Supreme Judicial Court was saying this should be given essentially so that the jury doesn't make the decision on mere negligence. And so, running from that, I would say this goes far beyond mere negligence. This isn't a person standing in his home and people are looking into his house. This is a person whose bedroom is on the basement. He's not in a common area. It's 3 a.m. He goes into the bedroom of his stepdaughter, who is 12 or 13 years old. The room is dimly lit. It has the fairy lights on. There is a guest in his home. She is a regular guest in his home. She is 12 or 13, and the two girls have spent the day together, and they are sleeping together in the one bed with the dog at their feet. He doesn't stand at the doorway and look in. He doesn't shield himself with the doorway so nobody sees him. He walks all the way into the room. He doesn't stay quiet. He is making noises. She knew it was a man's voice. She heard the grunting. That's what woke her up. He didn't stay far away. She heard him approaching, and he got close enough so that when he ejaculated, it landed on her ankle. And when she pulled her foot away, that's when he realized she's awake. So I agree with my brother. Intent might not be there because he ran out of the room then after he knows she's awake. So this is a recklessly case. But I would suggest these circumstances are so reckless that the definition isn't needed to be given. I cited 3 unpublished decisions.
Would it be helpful for the model jury instructions to have a supplemental instruction defining recklessly that should be given upon request by a party?
Oh, absolutely, and I think that's the law under Kessler. If the model should reflect what Kessler says, yes.
And should that instruction parrot the language in Kessler, which I believe, as Attorney Yellen said, is something to the effect of requires more than mere negligence or showing that someone might see the defendant? Would that be sufficient and
Yes,
proper?
I think that would be sufficient. That's my understanding of Kessler as well. And if that was requested here, I don't think anybody would have had a problem of giving it. But what the defendant is saying is the judge has to deviate from the model instruction sua sponte after the defendant has said he is satisfied and give this definition on an element that he has given to the jury twice.
Yep.
The jury asks questions. They don't ask about this. These facts are far beyond Kessler. He is inches away from a sleeping teen, and she is very upset after at 4 a.m. she notifies her parents. I disagree with my brother when he says you divorce pieces of the evidence to determine whether this applies to that or whatever. I think you look at the whole case and you see whether the instruction is required and whether it's required sua sponte, and you look at the whole case and you say, is this a substantial risk? And in these circumstances, I would suggest there's no substantial risk. Like the unpublished decisions I relied on in my brief, the closest one is, first of all, I fully acknowledge all of the unpublished decisions I've cited, people are outside. They are not inside their home. I would suggest the closest one is Bent. In the Bent case, the defendant leaves his home naked and goes into his neighboring apartment naked, and she sees him, she's upset, and he runs back out. I would suggest this case is like that because the defendant is not in his basement bedroom at 3 a.m. He is not in his bathroom. He is not in his living room or kitchen. He goes all the way into the bedroom where the guest is staying. And I would suggest that's why it's like Bent. He walks into that, what is essentially his stepdaughter's room and a guest room at that time. That's what it's being used for, and exposes himself, according to the victim's testimony, in front of these girls that he thinks are asleep, and he's noisy enough that he wakes one up. And that is not merely negligent. That's not an accident. Walking right up to the bed, noisily, that is the recklessness here, and that's why I think it's like Bent. The other cases are more public. My closest published case, I would cite to Pereira, which my brother on his brief at page 15 says that's a typically reckless case in Pereira. That Pereira is in his car. and you can't see what he's doing, but something's going on, and then the police officer walks over to him. When the police officer's at the window close, then the police officer can see what he's doing. And there are women and children all around. And even my brother cited that as typically reckless, and I would suggest that's what's going on here, that this is a typically reckless case. And I would also point to the instructions that were given in this case on a different element. The judge said the exposure had to be intentional, meaning voluntary or deliberate, not accident or negligent. So when he's exposing himself, he has to be acting not negligently. But this risk that he might be seen, the judge gave the proper instruction twice, he just didn't define it. And I think, like the unpublished decisions, it wasn't necessary here. I certainly have no problem with the instruction being given when requested, or if it becomes made part of the model instructions. I think it would have been helpful to the jury here, but the absence of that definition of recklessly did not create a substantial risk of a miscarriage of justice. I'm happy to answer any other questions.
I see no
Thank
questions
you.
from the panel. Thank you both very much. We appreciated your arguments and your briefs in this case. All right, we're going to move on to our first civil matter on for oral argument today, which is number 2023-0528, Town of Oxford, on behalf of the Board of Health versus David Blondin and others.
May it please the Court.
Good morning.
I'd like to begin by reciting a little bit of a nursery rhyme. I'm sure you all know. It's ring around the rosies, a pocket full of posies. Legend has it that that rhyme originated from the bubonic plague that was present up till the 17th century in England. There's a lot of controversy about that, but what there's no controversy about is the second line, a pocket full of posies. Science historians, including the Royal College of Physicians in London, all agree that at the time, the medical establishment believed that the plague was carried by noxious odors and that the sweet-smelling posies would ward off those odors and protect somebody who was bearing them. Of course, they had no proof of that. It was, at best, a theory or a superstition. I submit to you that the various public health orders from 2020 through 2021 imposed in dictatorial fashion by our governor had no better basis in science than the carrying around the posies. This case is emblematic of that contention. The town of Oxford couldn't.
Can I interrupt you right there?
Yeah.
So, assume hypothetically we agree with you. Assume hypothetically we agree with you for the sake of argument. Isn't there an abundance of case law that says a court order, even one that turns out to be subsequently to be wrongly founded, must be obeyed?
There are plenty of instances where you challenge a court order by violating it. Discovery orders happens all the time. In the free speech context, whenever there's a prior restraint, you challenge the order by violating it. Otherwise, you risk being held, by obeying it, that your grievances are held to be moot when the order expires or goes away. In this case, as the court well knows, we did promptly appeal that order and its legitimacy, and it was held to be moot, and then we got sanctioned anyway, after the fact.
Do you agree that the order was a clear and unequivocal command?
Oh, in that sense, yes. But the basis of the order, there are two prongs. I mean, if it's a private injunction, as we know, there are four prongs. For a governmental injunction, there are two. In the course, the leading case, which is discussed, I think, in both parties' briefs, is Commonwealth versus Mass Crink. And it stands for the proposition that the government need only prove a reasonable likelihood of success. I'll grant them that in this instance, and also must prove and make a showing of harm to the public interest. The Mass Crink case is notable for the fact that not only did it develop that doctrine, but it examined the injunction that had issued and vacated portions of it because it hadn't made the showing of harm to the public interest. That is something that the court below neglected to do. The court, in fact, because of the paucity of a showing by the plaintiff in this case, which consisted of two things: a hearsay statement, the WHO has declared coronavirus a pandemic, and the second is people in the town of Oxford have been infected. Nothing about lockdowns or what effect that has, nothing about gyms being a vector of transmission. And so the court, I think, was intelligent enough to realize I don't have enough to work with here, so the court goes shopping in other cases and grabs facts or factual findings from those cases, which in turn, and I've read them all and read the briefs and everything, weren't premised on any type of scientific showing. Through the years, and I've done a number of these cases, and I think every judge on this panel has sat on one of my coronavirus cases. I've challenged the Commonwealth, or the governmental entity as the case may be, over and over again, even at this late juncture, to muster this type of proof. But it doesn't exist. The fact of the court below harvesting its facts from other cases is extremely troublesome in so many ways. I don't think that courts, normally speaking, aren't trying to make up for deficiencies in a plaintiff's case and give them bootstrap them over the rail. Also, appellate courts don't typically find facts. And when facts are found by appellate courts by judicial notice, or affirmed by judicial notice, the parties in this court has held in the past are given an opportunity for notice and to be heard on whether the judicial notice is appropriate. Unfortunately, within the realm of coronavirus law, this idea of courts finding facts has, I hate to say it, it even infected the thinking of the SJC in Des Roises. But the SJC was, I guess, highly motivated to find that the Civil Defense Act covered public health, even though it says nothing in it about it, but it does have a clause that talks about naturally caused disasters. And the SJC, and I'm quoting from Des Roises, says, "We note first that COVID-19 is naturally caused as scientists believe it originated from an animal, likely a bat." That bat, we're almost 5 years beyond that now. And that bat soup narrative is way past its shelf life. I look at something like this, and the lawyer in me, I've taught these type of courses in law school. I'm saying, what scientists? What do they believe? It's just plucked out of the air. It's essentially, it's an abandonment of the rule of law just to...
But you would agree, may I interrupt, that we are bound by the court's decision in DeRosa's.
Oh, yeah, I'm not challenging Des Roises here. I don't need to for the purposes of this case, although I am criticizing the methodology in Des Roises, which I see as virtually identical to the methodology applied by the court below in this matter.
So if we accept it and you agree that there was an unequivocal order that was given to your client about, and then that is there any, what is the issue before us now? In other words,
An unequivocal order that was not based upon proper legal procedure, proper evidentiary foundation, and a proper legal standard. I invite the town of Oxford and the Attorney General to articulate, even at this late date, how the public interest would be harmed in the absence of this injunction. And I suggest to you that it can't be done except by assertion, except by blind belief. There is no data or research studies or epidemiological surveys that in any way support the lockdowns, the masks, the social distancing, none of it.
I'm going to go back to Justice Vuono's question and Justice Neyman's first question. Let's say in 3 years, 4 years, however long you want to go, that it comes out that the Governor Baker's order was wrong. It was based on improper science. Let's give that, let's say that's the hypothetical.
Mm-hmm.
The order still has to be followed. Isn't that correct?
The order has to be followed, but a party is also entitled to challenge the order. We never had that opportunity because, I mean, just to briefly go through the history of this case, we're older than Des Reusers, okay? And we applied for SJC review. They took Des Reusers. Why? Because Des Reusers plaintiffs were stipulating to all the facts. And we
excuse me, what did you just say? Because why?
The Des Reusers plaintiffs, who we're on the defense side, but that was a plaintiff's case. They stipulated to all the facts. They stipulated to the masking, the social distancing, everything. That was a pure constitutional challenge, which predictably went down in flames. And we decided we weren't going to do it that way, and we were going to challenge the order. It said the basis of issuing any such order at the time. And I don't think that we need to get so far as to have...
I'm still missing it. How do we, and I'm not saying we're going to do this, but how do we rule in your favor in this case? What is the method by which we can ignore DeRozier's and we can ignore the fact that there was a lawful order? How do you succeed in this?
Well, the second part, how can we ignore the fact that there was a lawful order? Our contention is it was not a lawful order. Our contention further is that the governor's orders were deeply in violation of equal protection type principles by exempting an elite class of the industry with no differential. These gyms are interchangeable for all intents and purposes. They have weights, they have machines. The Boston Celtics, for years, I think they still do, use the Hellenic College facility as a practice facility. That facility would have been exempt. If they practiced at Mr. Blondin's gym, he would have been exempt. I can't really get past that.
You agree on the equal protection and due process claims that it's a rational basis standard of review, correct?
Yes, I do concede that it is a rational basis standard. However, I further submit that there...
in your brief, you argue...
Yeah, the brief argues that quite thoroughly. I haven't
basis.
said anything about our counterclaims, and that's another legal fiction that was concocted down below, that this all happened under the public health statutes, or as a public health emergency. The public health statutes weren't in the citations against us. They weren't in the orders against us. The judge below even stated in her decision that she was basing it on the Civil Defense Act, or the orders under the Civil Defense Act. And the entire purpose of the Des Reusers case was to limit the government, that's what the plaintiffs wanted there, to limit the government to the existing public health statutes as opposed to the broad powers conferred under the Civil Defense Act. So the whole idea of this being done, in spite of the citation in some of the papers to the a public health emergency, even the public health law. It's in practice, it's a fiction, it's a fantasy. It's not what occurred here, and we had a right to counterclaim. We probably wouldn't have pursued that if the first decision had actually been decided on the merits, and we wouldn't be here today. So all of those issues are deeply troubling. I haven't talked much about my back of the brief argument, but I feel very strongly about it, Article 5 of the Massachusetts Declaration of Rights.
Let me ask you about that. That's a legislative abdication argument, is that correct?
Yes.
Is that, so that's grounded, essentially, it's a non-delegation argument, correct?
Well, it overlaps with non-delegation, but it isn't quite the same thing. I have articulated what I suggest is the meaning of that Article 5, which has a distinction from Article 30. And of course, I deeply disagree with the SJC's interpretation of Article 30, and I'm sure John Adams does too, but I'm not challenging that here. What I am saying is that if you undertake the type of delegation that the SJC has articulated as being appropriate, and you do it for long enough, and you do it in the absence of really any legislative activity on a broad array of things, you've lost the accountability of your legislature.
And what's your authority for the proposition that Article 5 is the correct vehicle to attack a legislative abdication issue?
It's plain language.
Plain language, okay.
Yeah, and my knowledge of history, which it tells me that in ancient Rome, the Senate there yielded voluntarily almost all their power to the emperor. They just became ceremonial. And I think that words in a constitution have meaning. But it's at the back of the brief for a reason. I think the much more fundamental issues
So your time actually is up. Yeah.
are ones that we've already covered, but thank you.
Thank you very much.
Good morning, members of the panel, and may it please the court. Roger Smerridge on behalf of the appellee Town of Oxford by and through its Board of Health. I'm going to be splitting time equally with the Assistant Attorney General representing the Commonwealth today. We have agreed that I'll be focusing on the Superior Court's contempt orders, whether this court may consider appellant's challenges to the underlying injunction, and if so, the factual and procedural grounds for the injunction. And the Assistant Attorney General will be focusing on the executive orders and the counterclaims. With that in mind, think back to the the late spring of 2020. Barely 2 months into an unprecedented global pandemic, the governor issued executive orders that eventually attempted to reopen in an orderly fashion businesses that had not been operating as essential. Both local governments and trial court judges had to figure out on the fly how to enforce those orders so as to protect the general public. Given that context, there was ample record support for the Superior Court's contempt findings and subsequent award of fees and fines here, even assuming that the appellants have preserved their appeal from those orders.
Let's assume that Attorney Jens is correct. Let's assume, for the sake of argument, that the governor's orders were based on false premises and were legally insufficient in retrospect. What impact does that have on the contempt findings and why?
I submit there's no impact, Your Honor. And my brother has already acknowledged that the injunction was clear and unequivocal, so that element of the contempt standard is undisputed here. I would submit there was clear and convincing evidence of the disobedience of the order, and the issue of the legality of the order cannot be challenged through the contempt finding. On reply, my brother has attempted to contest the Muhammad case, saying that there the court actually went, and I don't want to misquote him, but he says that the court there did not review the merits, or excuse me, did review the merits of the underlying order in Muhammad, but that's not the case. This court held that a judge who dismissed the plaintiff's contempt complaints committed reversible error by going beyond analyzing whether the underlying order was sufficiently clear, and instead attempting to determine the validity of the underlying order. And appellant's reliance on the Providence Journal case in their reply is similarly misplaced. There, the court held only that a party subject to an order that constitutes a transparently invalid prior restraint on pure speech only, and this is not pure speech here, may challenge the order by violating it. And the First Circuit identified this as a limited exception to the collateral bar rule that is exceedingly rare. The court's injunction here, as I said, was not a restraint on pure speech. This isn't like Providence Journal, where the injunction order prevented a newspaper from publishing information. Here, it's a restraint on business in compliance with executive orders during, as I said, an unprecedented pandemic. And the claim that the town was making was just that. It was an enforcement action. It wasn't necessarily based on the science or, all of that. It was the governor has issued orders. The orders say local boards of health enforce these orders, and we have evidence of a violation, and we're enforcing that. That's all the town's claim here did. So, and I do also want to note that the panel decision in the Providence Journal case that my brother cites in his reply brief was modified on rehearing en banc. And the full Court of Appeals stated that a party subject to what it perceives to be a transparently unconstitutional order of prior restraint must make a good faith effort to seek emergency relief from the appellate court before defying the trial court's order. Appellants didn't do that here. They did not file a Rule 6 motion for stay with this court. So there's just no basis on which they can find safe harbor under Providence Journal. Coming back to the question of whether they even have preserved an appeal from the contempt orders themselves, they only mention the contempt orders and resulting judgment 3 times in the argument section of their principal brief. And all 3 of those references are in passing. They're collateral to the contempt issues. They're actually addressing other issues. In fact, the 3rd one on page 50, they even say, what we're really trying to do here is challenge the underlying injunction. They admit it in their briefing. But Rule 16 makes clear that this court need not pass upon questions or issues not argued in the appellant's brief. And none of those 3 references to the contempt orders or subsequent money judgment rises to the level of adequate appellate argument on the question of whether the Superior Court abused its discretion. That's the standard.
Assume we reach the merits of that issue.
Yes.
What's your position?
Well, I just mentioned what the standard is. My argument is there was no abuse of discretion here. The contempt finding, as we discussed before, the underlying order has to be clear and convincing, clear and unequivocal command, and then there has to be clear and convincing evidence of disobedience.
Is abuse of discretion in this context the same as under LL versus Commonwealth, outside the range of reasonable alternatives?
Yes, Your Honor, and that's set forth in the Martinez versus Lynn Housing Authority case, which there again, it's contempt from an injunction. It's directly on point with respect to what the standard of review is. And there was clear and convincing evidence of disobedience. The town's health agent witnessed continued operations at the gym facility on June 5th after the injunction order was served, then on June 6th, 7th, and 8th of 2020. A week later, Mr. Blondin even posted a video to Facebook rallying people to come to his gym and use the equipment there at no charge. Given these actions, the town wasn't able to follow the Superior Court's order to secure and board the facility until June 19th, 13 days after the original injunction and 7 days after the Superior Court informed the appellants that it would impose a $1,000 per day fine for continued disregard. So given this, the Superior Court had evidence that supported a $7,000 fine for those 7 days. And then the town also provided the Superior Court with evidence to support the resulting fee award. It submitted affidavits an affidavit of its counsel detailing $424 in fees investigating the disobedience and preparing the contempt papers, and then additional fees for preparing the fee petition subsequently. There's no argument that there was an abuse of discretion here. The appellant doesn't challenge this.
Thank you very much.
Thank you. I'll rest on the briefs and the argument of the Commonwealth as well. Thank you, Your Honors.
Absolutely.
Good morning. May it please the Court, Douglas Martland, Assistant Attorney General for the Commonwealth Defendants. The Superior Court here properly dismissed the plaintiff's counterclaims for takings against the Commonwealth defendants and the town defendants. Turning to the Chapter 97 taking claim first, that's foreclosed by this Court's decision in Davidson. In Davidson, this Court held that a temporary restriction on an owner's property interest to prevent use in a manner detrimental to public health and to protect the public health is a proper exercise of police power that does not result in a taking. And that's exactly what happened here. The governor exercised his sovereign police powers to maintain public health during an unprecedented public health emergency.
So if a business is closed, they have no right to present evidence to the, in this case, the trial judge, that it was not detrimental to the public health to keep their business open?
They could have alleged that in their complaint. Here the claim was dismissed based on the paucity of allegations in the complaint regarding the use. And here in particular, the restriction that was imposed was a temporary negative restriction on the use of the property for the significant public purpose of protecting public health during an unprecedented pandemic. The restriction that was imposed was much less in nature than compared to something like Davidson, where the Commonwealth assumed entire responsibility for the operation of the facility during that period of time. And so, yes, Your Honor, the Superior Court here could, and this Court can affirm as well, just on the basis of the allegations of the counterclaims here. Turning briefly to the Civil Defense Act takings claim, which the plaintiff has distinguished, that fails on 3 counts. To establish a claim, Section 5 requires that there be a property owner and that the property owner establish a seizure and a taking of possession. And here the plaintiff's allegations, based on the complaint, they can't establish any of those 3. Starting with the most straightforward, as paragraph 5 of the counterclaim shows, and that's on Record Appendix 3, page 135, paragraph 5, they're not the owner of the property. All that this shows is that they have a leasehold interest. And here the legislature, when it was enacting the Civil Defense Act, made a choice that only an owner of the property would have a private right of action to pursue a takings claim under the Civil Defense Act claim. Anybody else with any other type of ownership interest would, of course, have a takings claim under the normal Chapter 79 route or a Fifth Amendment type claim, but not a specific private right of action under the Civil Defense Act. And so that alone is fatal here to the plaintiff's claim under the Civil Defense Act. But we can also look, the plaintiff did not establish, the allegations don't establish that there was a physical taking of possession of the property or that the seizure was in furtherance of the efforts to address the emergency. All they've established is that there was a temporary negative restriction on the use of the property pursuant to the governor's police power during, again, an unprecedented period of public health emergency. And then just this last element, the taking of possession, that fails for the same reason as the Chapter 79 claim. Very briefly addressing the Civil Defense Act, or claims here, the Commonwealth defendants are taking no position on the contempt award or anything like that.
So let me ask you about that. Of course, you write a comprehensive brief, and all parties, by the way, very comprehensive, thoughtful briefs, and we thank you for that. And you say, we take no position on this, so of course I'm going to ask you about it. Do you agree that the standard of review with respect to the contempt claim is abuse of discretion?
So again, we're taking no position.
Not a position, it's a legal question.
So we didn't brief that. I believe it is abuse of discretion, but that's not something we briefed. We have no interest here in the contempt award. That's a matter that's largely between the town and the plaintiff here, or the defendant. Our position is only if the court is going to allow what's effectively a collateral attack on the PI itself, that we would, of course, defend the legitimacy of the governor's orders. And I just want to address 3 points on that very briefly. First is that the DeRozier's case by the SJC controls almost all of Prime Fitness's argument, or the gym's arguments today, controls any argument about whether the governor's orders were within the scope of his authority under the Civil Defense Act. It controls any argument under Article 3 or non-delegation challenge that the SJC determined that the governor here had very explicit legislative authority and was acting to execute the laws of the Commonwealth. And it controls any due process, whether procedural or substantive, as well as free assembly challenges. Second point, the governor here had a rational basis for authorizing professional sports teams to reopen a brief period before gyms. We've established that there is a rational basis. The valid state interest here was protecting the public health and slowing the spread of COVID-19 during the pandemic. And there are ample reasons for the distinction between the few professional sports teams that exist in the Commonwealth and the many, many thousands of gyms across the state. One of those, as mentioned as a brief, is the strict regulation that the teams, the professional sports teams, were subject to, both by the Commonwealth as well as by their professional sports leagues, testing, safety rules, and the like, as well as the small number of individuals involved in the team element as compared to the thousands of unrelated and unaffiliated individuals across the Commonwealth who would be attending gyms once they were reopened. And I'd point the court in particular on this point to the discussion in DeRozier's regarding casinos versus arcades, which is a similar type issue that the SJC has already dealt with. It did so without fact-finding, just on the basis of the arguments presented in that case. And there it emphasized that casinos could reopen earlier in part because of the highly regulated nature of those facilities. And then just very briefly, the third point, Article 5 isn't a vehicle here for raising an Article 30 non-delegation claim, which again has already been resolved by the SJC and DeRozier.
Apart from the Arlington versus Board of Conciliation case, are you aware of any published opinion addressing Article 5?
No. And again, I would point the court to the detailed discussion in DeRozier's regarding the non-delegation arguments. What it appears to be here is the plaintiff or the gym shoehorning a non-delegation claim into Article 5 when it's already been resolved by DeRozier's. Thank you.
Thank you. Thank you all very much for your arguments. We'll take the case under advisement, and we'll take a 15-minute recess now. Okay, thank you. So our next case on the list is Department of Children and Families versus Child and Others. I remind everyone this case is impounded, so please don't use any formal names. The case number is 2023-1078.
Good morning, Your Honors, and may it please the Court, Attorney Morrison on behalf of the appellant mother. And myself and my sister counsel, the three of us will be splitting the time, so I will do my best to use my time as efficiently as possible.
Sure. Thank you.
Firstly, this case, DCF presented an unusually and insufficient thin case against the parents here. Only 3 days of trial, only, I believe, 15 or 17 exhibits, 5 of which were authored by DCF's own agents, and 5 of which were 209A orders introduced by the judge herself, and then entered into evidence by DCF at the judge's direction. The accumulation of error in this trial is alarming and illustrated the judge's efforts to bring DCF up and over the necessary burden of proof in order to terminate parents' rights. Firstly, the court's improper focus on mother's substance use in their findings illustrates that the court was looking for harmful evidence against the parents to meet the burden. However, DCF at the time of trial had no concerns about mother's sobriety, and the court found, in fact, that mother had been sober for at least 1 year at the time of trial, and that was including a positive test for cannabis, but there was also evidence introduced that mother had been sober for quite some time before that. So with the uncontested evidence and social workers' own testimony that clinically sobriety was no longer a concern and that mother's reports of sobriety were in fact correct, nonetheless, the judge made at least 13 findings and conclusions of law referencing mother's chronic substance use and failure to engage in treatment. And I'm just going to read shortly a few examples. Engage consistently with services to address her substance use or mental health. In conclusion number 5. Conclusion number 7, she provided no evidence of consistent long-term engagement in services to address her mental health instability and substance use. And conclusion number 16, mother provided no evidence of current engagement in substance use or mental health services to the department or this court. So these findings...
Let me ask you, so is your point that there is no evidence to support those findings or conclusion, or that they are contradicted, if you will, by the fact that there was evidence of sobriety for a period of time?
I would argue that there is not evidence to support the findings that mother was not consistently engaged. They're actually incongruous with other findings that the court made about mother's consistent engagement in her substance use issues and substance use treatment, and that the I don't believe insofar as the court was finding that sobriety was still a concern and a factor that should be weighed against mother in the calculus of finding her unfit, such findings would be erroneous given that there's no evidence to support the fact that she was not sober at the time of trial and had been consistently sober. So in terms of if the court is using that evidence to support its ultimate finding of unfitness, and I think it is clear from the court's findings that it was relying upon that evidence or that conclusion, that erroneous conclusion, then that would be error on the trial court's part.
Okay.
And just to quickly contrast with the evidence there was uncontested evidence that she was in AA and NA meetings. She was consistently in her medication-assisted treatment. She was providing drug screens and had positive and glowing reports both within the reports DCF filed themselves and within the social worker's testimony. And with that, I will...
I know your time is up, but of course, none of your arguments are weighed. We read your brief. I know it's difficult to put all your arguments together in a short period of time, but you don't think that anything is not going to be considered. We will consider everything.
Thank you, Your Honor.
Thank you.
Good morning. May it please the court. My name is Attorney Svetlana Gerova-Wilson. I represent the father in this matter. Yes. Father is also appellant. Even though at trial he did not ask for custody of the child, he was seeking custody to go to mom, and he wanted to be to co-parent with her, but primary custody would remain with her. He is seeking to reverse the judgment for several reasons. I don't obviously have time to go into all of them, but I want to focus on the due process violation and consisting of the judge on the third day of trial introducing out of her own accord 209A abuse prevention orders, which she requested from the probation to run. She requested the affidavits, and she asked for them to be included in the record and consider them substantively. They were not, those affidavits, those...
Eventually, they were introduced by DCF, correct?
So they were introduced to DCF after the objection of father's counsel and mother's counsel and child's counsel, I believe. And then the judge said, well, if this is the case, DCF, would you like them in? I think this is overreaching. So I know there's a Norbert, the adoption of Norbert case that I mentioned in my brief, that something not similar happened, but the judge asked so many questions, more questions than all of the other litigants. But it's a very different situation because the judge does have a right to ask questions, to clarify. But in this case, there was no clarification. It was new evidence that the judge sought out and tried to introduce. After the objection, the judge prompted DCF to introduce and then relied on them substantively.
What do you mean by new evidence?
So those restraining orders, I mean, they are mentioned throughout the record, but they're not part of it. They're not in any party's exhibit list. Those affidavits, they were not part of the record until the judge sought them to become. And this is troubling because even if everybody knew they exist, it will be akin to knowing that somebody went to the hospital, but we don't subpoena the medical records. It would have been the same, similar situation if the judge actually sought my client's medical records, for example. It was new evidence that was not presented by either party.
Well, so let me ask you a hypothetical. What if this case involved alleged injuries sustained by the child, and the medical records had not been put into evidence, but there was testimony about the injuries? Would a judge abuse her discretion under those circumstances in saying, I'd like to see the medical records, and I'm going to have them admitted into evidence as an exhibit? Would that be a problem when ultimately part of the judge's decision hinges on the best interests of the child?
So it really depends on case-by-case basis. I mean, you're giving me like a very narrow circumstances under which it does sound reasonable to ask that question, right? However, I do think that in general case, it would still look like the judge would be at least showing a appearance of impartiality.
But how can a judge, so in your case, the issue of domestic violence was at issue, correct? That was a live issue at trial?
Yes, it was. Well, this was the only issue, it's my argument, and also in my brief, because DCF has stated in their record, and I've cited the pages in the record, that substance abuse is no longer an issue.
So how can the judge make the determination about whether the domestic violence issues were substantial enough without seeking information such as the content of the restraining order? Wouldn't that be a critical issue for the judge to review, again, vis-a-vis best interests of the child?
Well, in this particular case, it wasn't. So the judge actually saw them beforehand and then asked to be introduced. So it did appear like the judge had decided what those records are going to show. So it's not exactly like the hypothetical that you're offering. So in this particular case, I'll submit to the court that it was at least created the appearance of partisanship, and it was not a harmless error in these particular circumstances, and it would warrant a reversal. And I see that I'm really out of time. And I'll rest on my brief.
Again, I'll tell you the same thing, that, of course, all of your arguments in your brief, we've read your brief, and we will consider them.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Julia Healy, and I represent the appellant child in this matter. Nothing else matters in this case if the trial judge didn't have the authority to do what she did, and she didn't. The trial court did not have the authority to terminate mother's parental rights because mother did not file a petition for review and redetermination. Since mother, DCF, nor the child filed a petition for review and redetermination, there was no vehicle before the court by which the court could reevaluate mother's current unfitness. As the issue of mother's fitness was not properly before the court erred in denying the joint motion to vacate the court's decree terminating mother's parental rights. Parties cannot agree to try, and a court cannot act on an issue not raised by the petition that was not before the court. Adoption of Reed, which has been law in this Commonwealth for, I believe, 29 years, is very clear that a court decree does not reflect the party's understanding of what was going on in the case. A court decree must be based on an issue or a matter that was properly before the court. And in addition, serious problems may be created when a judge bases a decision on something that was not before the court, and I believe that's adoption of Reed at 342. In this case, there was no vehicle under which the court could consider mother's fitness. The legislature in 11926 specifically gave the power to the parties to determine if post-adjudication hearings should occur. A party must file a petition if they are seeking a post-adjudication remedy, such as the child being reunified or the child being adoption. Care and Protection of Isaac is clear that 26C, a review and redetermination petition, is how a party raises that change in circumstances. A court cannot sua sponte do that. The only way for mother's unfitness to be before the court was for mother, DCF, or the child to file a review and redetermination. Footnote, DCF could, under 11926B4, I believe, have filed a motion to amend the petition and sought a trial on that amendment, but they did not do that. The only action vehicle before the court was father's petition, in which father alleged that his circumstances has changed. That's Appendix 139. No one in any petition raised the issue of mother's unfitness.
And this was not raised before the judge, correct?
I'm sorry, Your Honor?
This was not raised, the issue you're making right now.
It was raised, Your Honor. It was raised, so the hearing on the petition was in November and December, I believe, of 22. In June of 22, there was a pretrial hearing on this issue, and it was when the court scheduled the trial date. And at that hearing, father said that he was unclear if the motion could go forward because he was seeking custody to mother and not to himself. Mother said, I am not seeking review and redetermination. I want more time to work with DCF toward reunification. And DCF at that time opposed father's petition for review and redetermination. At the hearing, it changed its tune, but in June of 22, it opposed the hearing. The court scheduled the matter anyway. So my sister from DCF is not correct in her brief when she says that the issue was never raised. It was raised about 6 months before the hearing. There is a reason that the legislature gave the
hearing, you mean the trial?
It was a hearing on father's petition. It was not a hearing on the merits, Your Honor. It's a very big difference.
No, when you said it was raised 6 months before the hearing.
Yes, sir.
Okay.
It was raised in June, and the hearing was in November and December, I believe. It is against public policy to allow one party to use a statute to retaliate or sabotage another party. I am not claiming that's what happened here. I believe father acted in good faith, but that doesn't matter. What matters is that these cases involve contention often between the parties. They often involve power imbalances, such as domestic violence. And the legislature did not intend to allow 11926 to be used for one party to control the other. And imagine what could happen. Imagine one party saying to another, you have to get back with me, or you have to do whatever it is I'm telling you to do, or I see that you're slipping. I see that you're doing something that doesn't look good. I'm going to file a review and redetermination, and I'm going to bring you back, and you're going to get terminated. That isn't what 11926 is about. 11926 is about a party feeling that they are in a good position, they have been rehabilitated, and bringing themselves before the court, or DCF as the opposing party coming and saying, Your Honor, I think now that I need to move for adoption. But it was not meant for one power to gain control over another part. It would weaponize the statute in a way that I'm sure the legislature did not mean to. It also contravenes public policy because it impacts the child who wants to maintain a legal relationship with the non-moving party. And remember, Chapter 119's purpose is to promote the child's well-being, and the bond between the parent and child is accorded great weight by the court, and that's in...
Counsel, what do you say to DCF's argument that the court sua sponte has the right to bring this issue up?
The court absolutely, Your Honor, does not have the right sua sponte to bring this up. 11926 delineates who may bring a motion for review and redetermination. That's a person with custody of the child, a probation officer, a guardian, attorney, or GAL of the child, either parent or DCF. The court is not in that enumerated list. If the legislature wanted the court to be able to bring this up, and again, Care and Protection of Isaac says a review and redetermination is the way to seek post-adjudication hearing, they would have put the court in that list, and they didn't. Court cannot sua sponte do this, and that's what the court did in this case, and that's why the court erred. But as a matter of principle, one party should not be able to raise another party's fitness at a review and redetermination. It contravenes the meaning of 11926. And I see my time is almost up, so if there are no further questions, I will rest on my brief. Thank you very much.
Good morning, Your Honors. Assistant Attorney General Rebecca Krumholtz for the Department of Children and Families. The Juvenile Court, in a thorough 71-page decision, which includes extensive factual findings, correctly determined, based on clear and convincing evidence, that mother was unfit to parent child and that terminating mother and father's parental rights is in the child's best interest. The record evidence amply supported this conclusion. In this case, a true constellation of issues contributed to the court's termination decision. Chief among them was the pervasive and persistent domestic violence and volatility in parents' relationship, and mother's demonstrated inability to distance herself, time and time again, from father. Indeed, far from severing ties, the record is replete with evidence that mother consistently prioritized maintaining a relationship with father over both her and her child's best interests, and over taking available steps to remedy her parental deficiencies and regain full custody of child.
So we don't often talk about it in these types of cases, but you agree DCF has the burden, correct?
Correct.
So how do you justify that a judge who is impartial asks to have DCF introduce evidence to support their claim when DCF had no intention of doing it in the first place?
The judge requested, initially introduced the idea of the 209A orders being introduced as evidence in order to provide context or complete the record. In this case, the judge is also the fact finder, and in that context has an obligation to ensure a full record is before her, particularly in a case where the best interest of the child is the primary question. But regardless, there was absolutely no prejudice by entering these orders. As stated by my sister counsel already, the evidence was already in the record that these restraining orders existed and also why they existed.
In your experience, is it common for the actual restraining orders, affidavits, full information to be admitted as exhibits in cases involving domestic violence in the context of an unfitness and determination?
My understanding is that they can be admitted.
I understand they can. Is it your experience, does that typically happen?
I can't speak to my experience, but I know that they are admitted readily in these kinds of cases. And in this case, the question of domestic violence was central to the court's finding, and throughout the social workers' reports, the social workers' testimony, there's evidence of this domestic violence.
So do you know why trial counsel for DCF didn't seek to introduce them at trial initially here? In the record, which would help us out?
I think that without them, the record is absolutely sufficient to satisfy the DCF's burden, and perhaps that might be why, but that would be speculation. I don't know. Going back to the question of domestic violence, mother knowingly violated her conditional custody order and reunited with father despite awareness, having been told by DCF that that would not be a safe environment for child. She also lied to DCF about the conditions of that custody order in order to reunite with father. After child was removed, domestic violence in mother and father's relationship continued. Mother failed to sever ties with father despite multiple instances where she reported both verbal and physical abuse. In several instances, she obtained a restraining order and then sought to have it vacated, moved back in with father, and rejected attempts by DCF to provide services to address the domestic violence, particularly when it didn't benefit her specifically in terms of getting reunited with her daughter. But it wasn't just domestic violence that the court relied on. It was just one factor of several others. And each of these additional factors really go toward the finding that mother was unable to provide a safe and stable and secure environment for child, particularly given the unique and complex special needs of this child. These included mother's substance use, mental instability, and failure to engage in services, and I can touch upon these briefly if there aren't specific questions.
Well, there was evidence that there was significant improvement prior to trial, at the time of trial, correct?
For substance use, are you referring to? Yes, and mother made commendable progress there in terms of her opioid abuse, however, and substance abuse. But the court did find that mother still failed to appreciate the impact of her substance use and demonstrate insight into how the substance use may impact child. And specifically, mother still failed to complete residential programs. She was given 2 opportunities to do so and a 3rd opportunity in the spring to re-enter and rejected that opportunity. So certainly the risk of relapse still exists, but I think we can even just setting that aside, the court certainly considered both the past evidence of substance use and her current sobriety in making this determination. And what the court found was that mother's use of marijuana consistently, at least twice, caused disruptions in child's care, in her own ability to obtain the services that she needed, and resulted in her making poor decisions, including violating the custody order. And ultimately, that resulted in child being removed. And I just want to add that this choice to use marijuana not only impacted housing, mother's ability to complete these residential substance use programs, but also meant that child did not receive the early intervention services that she had qualified for at the first residential facility, because mother did not transfer the program to a new local provider. That meant there was a large gap in services for child. When child was removed from mother's care in November, December of 2021, the severe developmental delays and other issues were apparent but had not been addressed. Child could not sit on her own at 11 months, could not hold a bottle, and other indications that there were real developmental delays. It was not until child ended up in the care of her current foster family and pre-adoptive family that those issues were immediately addressed, tended to, and continue to be treated with a whole team of providers. To the mental instability, again, this goes to the court's finding that that mother has demonstrated time and time again an inability to provide a secure home environment for child. In that context, the court really looked to mother's adversarial and combative relationship with DCF, sort of her waning engagement with DCF as she became more frustrated with them, and her lack of willingness to hear other opinions, except that perhaps she might be doing something wrong, or that she could improve herself, rather than blaming the department and others. And again, the court looked at that in the context of the particular needs of this child, the complex needs, the fact that child needs an incredibly attentive caregiver who's going to be receptive to the opinions and advice of all sorts of our entire care team, which is quite large. And finally, and very briefly, mother's failure to engage in services. I recognize she did engage in a number of services, but failed to benefit from them. And then there are other services that she did not engage in, and some that she engaged in for some time and then ultimately abandoned. And again, this is just important. The court found this was important, and the evidence reflects the importance of this, because child has a myriad of health issues that require all sorts of appointments, consistency, a provider that's going to be predictable, and the record demonstrates with clear and convincing evidence that mother cannot provide that kind of home for child. The record also demonstrates that mother's unfitness was not going to be cured, that the unfitness was, that there was not a likelihood that mother would become fit or father would become fit. And I think, just to point to one piece of evidence, and the rest is covered in my brief, just the fact that mother really was unable to benefit from the services that she was offered. Just one example of this is while she was at Angel House, receiving a whole slew of domestic violence-related services, engaging in programs and groups, learning about codependence and all these other things. Mother was still speaking with father nightly. She was telling her social worker that she wanted to reunite with father, that she wanted to go to a family home with father and child. Again, this is incongruent with the lessons one would learn from these domestic violence services. Again, she rejects those services later, and is...
Counsel, your time is running low, and I want to address the issue of whether a judge sua sponte can raise the issue of mom's unfitness. What do you say about that issue?
Yeah, so the judge cannot raise the issue of mom's unfitness, but that's not what's at stake here. Here we have a review. We have the reconsideration, but that's separate from the fact that the reconsideration proceeding is a care and protection proceeding. Any party may seek an order or decree terminating parental rights at a care and protection proceeding. That is what DCF did here. DCF provided ample notice that it was doing that. It provided notice on November 4th, a month before the trial began. There was no objection to that notice.
When you say provide notice on November 4th, what exactly are you referring to?
Notified the parties that it would be seeking termination at the proceeding.
There was not a new petition or a new motion filed or anything like that.
And that's not necessary under 26.4. There are some circumstances under which a petition would be necessary. This is not one of them, and I point you to a footnote in my brief concerning that. I believe it's footnote 11.
Excuse me?
Footnote 11. Yeah. And there's a citation there. So in this case, there was ample notice provided to all parties that DCF would be seeking termination at this care and protection proceeding. There was no objection to that notice. On the first day of trial, right off the bat, DCF's attorney said, seeking termination, no objection. The parties then proceeded as if all under the same understanding that termination was on the table. And if you read the closing arguments, it's very clear that everybody believed that's what was at issue. It wasn't until the court terminated the rights that then the child and mother sought to vacate that termination based on this argument. I'll add that the reconsideration hearing, which was what initially prompted this care and protection proceeding, is a proceeding to evaluate whether the child is still in need of care and protection.
Can I ask a procedural question? Could, at that point, DCF filed a petition for the unfitness of mom? Would that have been permissible at that point?
Excuse me, just at what point?
Once Dad had filed the motion, could DCF at that point, because you said it would be abundantly clear that they were going to seek mom's unfitness, could you have filed a new petition at that point?
I don't believe it would have been necessary. It's this notice of
It
intent.
wouldn't have been necessary, but could you have?
I suppose DCF could have sought a separate hearing on termination, but that wouldn't have been necessary. This was a hearing on the merits of parental fitness, and so during that proceeding, termination can be sought by any party. I see that my time is running short. I don't know if, all right.
Thank you very much.
Your Honor.
Thank you all very much for your arguments. We'll take the case under advisement. All right. Now reach the last case on our list today, which is case number 2023-1353, Cobble Hill Center versus Somerville Redevelopment Authority. Just one moment, when the light goes on, you can start. It'll just be a minute, I'm sure, or seconds. There you go. Still morning. Good morning.
Good morning, Your Honors. Tad Hewer on behalf of the Somerville Redevelopment Authority. I have 3 points this morning. The first is why plaintiff's inflammatory closing argument was so prejudicial to the Somerville Redevelopment Authority, the SRA. Second, which is why all 4 of the Fife factors are met here, warranting reversal or warranting relief on direct appeal. And then third, why the denial of the motion for the new trial warrants reversal. So first, this eminent domain trial should have been about a single objective factual issue, the fair market value, and that's defined as the price a hypothetical buyer would pay a hypothetical seller of 90 Washington Street. This is a classic, if admittedly somewhat boring, battle of the experts. Instead, plaintiff's counsel's closing repeatedly injected the inflammatory demand that the jurors settle his client's subjective grievances with the SRA. He impugned the SRA for allegedly unfair treatment of his client. He urged jurors to consider when the government had treated them unfairly. And having baited that hook, he then reeled it in, telling jurors they had the opportunity to hold the government accountable. And he encouraged the jury to decide this case based on their subjective determination about whether the actual parties, Cobble Hill and the SRA, acted unfairly toward one another. And that's a question the jury was neither charged with deciding nor under eminent domain law is even allowed to consider. Now, plaintiff's
And the judge cured the issue.
The judge issued a curative instruction. That's true. And that's the second Fife factor, or the third Fife factor. But curative instructions aren't talismanic. They need to be effective.
And isn't it counsel's obligation, after a judge tries to cure an issue that if the lawyer doesn't think it's appropriate to ask the judge to do more to cure it, and in this case, the judge specifically asked counsel, I'll paraphrase, are you satisfied? And the answer was yes.
So I think this distinction is the difference between mistrial and new trial to some extent. So we know that mistrials are not supposed to be favorably granted. They happen in the moment. They can't be reserved anymore. That's the Fitzpatrick case. So you have a situation where the judge says, sua sponte, this was inflammatory, right? There's no question about whether this conduct was inflammatory. The question is what you do about it. So here the judge says it was inflammatory. I instruct on my own while you're just walking up to sidebar. When you get to sidebar, he then says, right, what's your problem? And the seasonal objection was made, right? What you saw, Judge, was the same thing that SRA's trial counsel said he saw. The difference here is that a mistrial is not supposed to be granted, so we're all trained not to really ask for them. You ask for the curative instruction because you hope that that's going to be sufficient.
Let me stop you right there.
Yeah.
Trained not to ask for them. I'm not sure I would agree with that. It seems to me that as trial counsel, if you feel that the curative instruction given is insufficient, then number one, you say, Judge, not good enough. Here's some language I'd like you to give to the jury.
Sure.
That wasn't done here.
It wasn't.
So, two, the other option you have is to move for a mistrial because it gives you the opportunity to explain to the judge, as you're doing now on appeal for the first time, well, strike that motion for new trial. It gives the judge the opportunity to hear you and to understand exactly why you are saying there is prejudice and it cannot be corrected. In other words, that this closing argument is so egregious that no instruction will cure it. And the fact that that wasn't done here is suggestive, it's not dispositive, but it's suggestive that at trial you were satisfied with the instructions and felt that there was no undue, insurmountable prejudice.
Correct.
That,
No.
in my view, is the hurdle you have to overcome right now.
Right. So I would note that I wasn't trial counsel, so I'm speaking for them, but not
Understood.
being them. That being said, when you move for a mistrial, you're saying we need to cut off this trial right now. It's so egregious that it has to stop. We've been here for 2 weeks, but this moment it stops now. The hope is that the curative instruction cures, right? And I think that's what trial counsel wanted. They said, you offered a curative instruction. That sounds reasonable. We will take it. But then what happened is the jury returned a verdict, and the verdict was higher than what even Cobble Hill asked for, right? Not by much, but it was higher. At that point, it's clear that that bell couldn't have been unrung by any instruction.
How is that clear? How does it flow that because the jury came back with an unfavorable verdict to your client, that by definition it was the closing argument that was the root cause of that?
It's not by definition, but that's not the standard we have to meet here, right? What we know is that we had inflammatory argument. And then we know that we get a verdict back. It's the combination of those two, because what we don't know is whether the jury listened to the plaintiff's expert and said, I'm going to reach that result through cool mathematical calculation, or whether they listened to plaintiff's counsel and decided they wanted to teach the SRA a lesson.
What about all of the case law that says we presume that juries follow judges' curative instructions?
We certainly presume that, but we see in Fife that Fife says that that's not always sufficient. And I think our case that we cite, I think we both cite it, we both cite very similar cases, is Warner. And Warner says, that's First Circuit, even when a trial judge does everything possible in an effort to have the jury banish from their minds the thought which plaintiff's attorney has improperly injected, and we know that occurred here, that is not legally sufficient where there's a strong likelihood that the repeated references had a profound effect on the jury's fact-finding. And that's what we're saying happened here, that they came in at a very high number, higher than what they asked for. I will concede to the court right now, if they had come in at a number slightly lower, we would have a much harder case here. Right? If they came in at, so the number was a little over 35 million. They came in at 33 million.
Do you have any case that says that the result of the jury is something we can consider as to how egregious the closing argument is, or the improper evidence that's admitted?
Absolutely. That's Fife. Fife says that. Fife says you look at the jury verdict. That's your fourth question, right? So Fife has 4 factors. It's, was there a seasonable objection? There was. Does it go to the heart of the case? It did. The only thing we're talking about is damages here. Was there a curative instruction, and was it sufficient? We say it wasn't. And then you say, did that conduct potentially, could it have had a material difference in the jury's outcome? And Fife says that, yes, you had a verdict there that was at the upper range. And when you say you have the upper range combined with the improper conduct, we can't distinguish and differentiate whether the jury did it for permissible reasons or whether they did it for prejudicial reasons. And that's the box that plaintiff's counsel has put the parties in. We can't look and go ask the jury, which one was it? So Fife says, we're going to create a test. And if those 4 factors are met, then we say there was prejudice that affected my client's right to a fair trial. We don't allow in our system reaching the right result for the wrong reasons, right? We don't say, was it a fair outcome? We say, was it a fair trial? The process matters here. And the reason it matters is because we can't go ask the jury. So once you have a situation where the verdict is at the upper end of the range and you have inflammatory conduct, we don't know which way the jury was thinking, and we have to look at that situation, give the benefit of the doubt to the defendant. It's the plaintiff's burden in this case to prove, and we have a defendant who is improperly impugned by the conduct during the closing argument.
I have 2 questions for you. The first is a quick procedural question. Did you seek remittitor?
Sorry?
Did you seek remittitor in this case?
I don't believe we did.
Okay. My second question is, at page 19 of your brief, it lays out the issues with respect to the closing argument of your brother counsel. Is it fair to say that that is essentially the universe of the statements that you're challenging on appeal and that you challenged at trial?
Yes.
So the third bullet, how does the government treat you? What's your common experience about how the government treats its citizens? I understand that one. What about even the government can be held accountable? And the other one is the first one. The government hasn't been close to being fair to my clients. Why is that not, does that not fall into the category of excusable rhetoric or hyperbole?
Because it's talking about being fair to one's clients in a jury trial where fairness to the clients has 0 relevance whatsoever. Eminent domain damages trials are about hypothetical buyers and hypothetical sellers. Whether the government, an actual party, was fair to the client, the owner, another actual party, has absolutely nothing to do with finding the right eminent domain damages number. And we see this in, their brief says, well, both sides talked about fairness. And the judge also said, well, you both talked about fairness. Can't you both talk about it? There's a key difference. Somerville said fairness was, phrased it in an objective way. Fairness is whether the buyer is getting the fair market value, the price. Cobble Hill was subjective fairness. Was this government fair to me? The first one is the legal definition of fair market value that has to go into the charge. The latter is prejudicial error. So any references to being fair to my clients are not relevant in eminent domain matters. And I think
how about even the government can be held accountable?
Sure. So government being held accountable is viewed in the context of these statements, right? That's what I said. It's you set it up and then you reel it in. It's the closer. So you have a situation where you say, they haven't been fair to my clients. They haven't been fair. What would you do? All right? Are they fair? Are they unfair? What's your common experience about how the government treats its citizens? How does the government treat you? And then says, and even the government can be held accountable. That's saying to the jury, think about yourself and then do something about it. And we know this because if you look at the judge's order on the denial for the new trial motion, right, that's Record Appendix 5, page 513, he actually says, right, this was an inflammatory conduct about holding the government accountable. Right? The judge recognized that this was all of a piece. And if you see the objection in the transcript at the sidebar, this is page 2025 of our appendix, line 14, the SRA objected to, quote, any notion of whether the government is fair to them. It's not just the abstract rhetorical statement, it's do something about that. Do something. Hold them accountable for not being fair to my client. That's the problem. And the reason it's even more egregious is because we know that there were jurors in that jury pool, on the jury, who at the panel voir dire, so everyone is sitting out in the open hearing everyone's comments, says, yeah, I remember there was a situation where the government took land, I can't remember if it was a neighbor or someone else, and I didn't think that was fair. I didn't like that. They know they have jurors who are already disinclined to believe the government. And it goes right to those jurors. It says, did you believe this? What if that were you? Do something about it. And that's the problem.
Does it matter, under your argument, when counsel objects to the closing?
Broadly, yes, they have to have objected at the closing. They can't be subsequently.
Well, at the closing in the sense of in the middle of the closing, right when the prejudicial remarks are made, or at the end and asks the judge to give a curative instructive, did that make a difference?
I think when the curative instruction is given does make a difference, and we know that because the judge said at the motion on the new trial, he said, if I could have done this differently, I would have done it at the time. I would have interjected when the statements were made, because the way he did it, he said, was less effective. So even he is recognizing that the timing of his curative instruction may not have been sufficient. I think the practical fact is that you almost never object to closings during them. It has to be.
That happened in Fife, though, right?
It did happen in Fife.
They objected in the middle, and that was highlighted in the case.
Right. So you can do it. I'm not sure I have ever done it, even if there's been a situation where it seemed to be warranted. You kind of wait to the end because you don't want to highlight the thing that was so problematic. You hope the judge will make a curative instruction. But if you look at the transcript, and again, I was not there, but if you look at the transcript, it appears the judge is recognizing when he's saying, right, we're now done, you're going to come up. He sees that trial counsel was uncomfortable during this, and he said, right, that's why I made that instruction while you were approaching sidebar. He knew there was a problem. He saw the look on counsel's faces. We all look up at the judge and give a glance and say, is that really on? That seems to have happened here. So the judge knew, and the judge said, tell me what the problem is, and I think he says something along the lines of, I have some idea of what you're going to say. Yeah. So everyone, counsel and judge, knew that that was going to be the topic of discussion. Whether it was objected to at the moment by counsel and raised it for the jury is one thing. When a judge does it and says, you can't say that, that's quite different. I think the jury views the judge as the impartial arbiter. They view the advocate as an advocate. And I think many of us don't want to be seen as playing points on somebody else's closing.
There's one more question for you.
Yes.
In Fife, in addition to the closing argument being held to be, well, strike that. In Fife, was the case reversed solely based on the errors in closing argument or based on other errors during trial as well?
It was other errors. I think Fife is one of those cases where everything that could have gone wrong for the plaintiff's counsel went wrong, and usually through his fault.
Can you cite a published civil case in Massachusetts where the verdict has been reversed solely based on inappropriate closing
Fitzpatrick v. Wendy's Hamburgers, which we cite, Stiles, which we cite, London, which we cite.
In all three of those, that's the sole error.
That's my recollection. So Fitzpatrick is the case where the closing argument is about the woman who bites into the hamburger with the bone in it.
Yep.
And there the issue is that he says you should hold the big corporations accountable. How do you think about them? And that was the issue that I recall Fitzpatrick was on. London is a much older case, but still is good law. Sure. And Stiles is not an appellate case. It's a trial case.
Thank you.
All right.
Thank you.
Thank you very much.
Good afternoon, Your Honors. My name is George McLaughlin, and I, along with Joel Fowler, represent the appellee in this case, Cobble Hill Center, LLC. I was trial counsel in this case, as you may know from having reviewed the record. And let me say at the beginning that this case, as you know, an eminent domain case, is about the plaintiff's constitutional right to fair market value in a case. Fair market value is not, as Mr. Hoyer defined it, as the price that is owed. It's the highest price that is owed. And we talk about, in these cases, not only fair market value, but fairness, because inherent in the definition of fair market value, as the trial court judge found, and as both I argued, and as both trial counsel, Mr. Masterman, argued, is fairness. The government has this awesome power to take someone's property, in this case my client's, against their will. So with that awesome power comes an equally awesome duty of fairness. Now, fairness was argued by Mr. Masterman in his opening and in his closing, and it was argued by me in my closing. But, and I want to get this out of the way right off the bat, I've tried a lot of cases, when you have an appeal and you have the opportunity to look back and see what you said, I agree with what the judge said, with what the trial judge said in this case. I think I did what he described it. He didn't describe it as inflammatory. He said that in one of his decisions. But during the trial, right after he listened to my argument, he said words to the effect of, I think it was, quote, slightly over the edge, close quote, and he said, I think it was, quote, slightly over the top, close quote. Now that upon cool, calm reflection I've had the opportunity to look at it, what I was really doing there, and you can see it in the transcript, I was saying to the jury, don't leave your common sense at home. Nothing wrong with that argument. Where I stepped over the line is when I said, think about how the government treats you.
That's my first question. You would concede that how does the government treat you is over the line.
It's over the line.
It's error.
It's error.
And what's your common experience about how the government treats its citizens is error?
Yes. I went over the line, Your Honor. And I'll never make that argument again. You know, it's the practice of law, and I'm not perfect. But that was not the reason how the jury decided that this case. And let me point out a couple of other things, and your questioning got onto this. As we all know, you have to object at the time of trial. And the reason why you have to object is because you're all judges, obviously. The judge has a difficult rule. He's listening to all this evidence. He's listening to all these objections. You have to point out to the judge what was wrong and give the judge the opportunity to correct it. Somerville's saying everybody made mistakes here. I made mistakes. The judge made mistakes. Everybody made mistakes. Well, the judge didn't make a mistake.
Well, they did object at trial. Are you saying that there's an obligation to object in the middle of the closing argument?
Absolutely not, and I think that's...
Trial transcript, volume 5, page 2025, they did object during
trial. They did object, but what happened after the objection, Your Honor, is Mr. Masterman came up and he objected, and even before he objected, the judge gave an instruction to the jury at the end of my closing argument, and he basically said, ladies and gentlemen, this isn't about how the government treats you. This is about fair market value. So in closing argument, you know, attorneys get passionate and what have you, but I just want to draw your attention to the fact that this is about price. This is about fair market value. This isn't about holding the government, you know, how the government treats you. Then Mr. Masterman came to sidebar, and he said, you know, what's your objection? He said, well, that's my objection, Judge. He shouldn't have made that argument. And the judge said, I agree. And then Mr. Masterman said, you know, I don't think it's a mistrial. Now, what we have going on here is we have a lot of trial strategy going on. Masterman's there trying the case for 2 weeks. He thinks it's going well from his perspective. He could have moved for a mistrial if he wanted to, if he thought it was so bad. He didn't move for a mistrial. That's trial strategy. You cannot change trial strategy, as this court knows, on appeal. And that's precisely what Somerville's trying to do. They're trying to say that even though the lawyer who tried the case says to the judge, this isn't a mistrial, and then he tells the judge that he's happy with his instruction, What did the judge do wrong? You know, Fife talks about prejudicial.
I'm sorry to interrupt, but how does this get back to your point that they have to object at trial? They did.
They did. But then they objected at trial. This is my point, Your Honor. They objected at trial. There was a curative instruction. And then they said they were happy with the curative instruction. And they only objected to one argument. Now they're arguing 5 arguments where I made a mistake. And if you don't object, it's basic black letter law, as you know. If you don't preserve the objection at trial, then you waive it on appeal. The only time a judge can consider unpreserved objections is in a motion for new trial. And, you know, as we all know, that's a very difficult standard. That's the miscarriage of justice standard.
So did they waive any further objection when they objected and the judge gave the curative instruction? Are you saying that at that point they should have said, we still object to that instruction?
Precisely, and that's what the case law says, Your Honor. That's what the case law says. And again, it gets back to, what did the judge do wrong here? They're saying under Fife that the judge is guilty of prejudicial error. Well, if a judge is guilty of prejudicial error, then the first thing you have to find is the judge made an error. What's the error when they object? And this is the sequence. Judge gives a curative instruction on his own. He says to Mr. Masterman, yeah, I agree with you. That was improper argument. I'm going to give another curative instruction. Is that okay with you? And he says, yes, Judge.
And they agree to that. We know the record. So let's get back to your point, though. You've just made the argument that only one misstatement by you was the subject of their objection. Again, Record Appendix Volume 5, page 2025, Mr. Masterman says at the end of his objection, and I request the court give a corrective instruction that any notion of whether the government is fair to them plays no part in this case. That suggests to me that that does preserve all of the references to government unfairness.
Well,
so it strikes me that they preserve the issue.
On that argument.
They waived it as to mistrial, but they did preserve it as to any reference to the fairness of the government.
I agree with that.
So that is all of the statements at their brief at page 19 that are in the bullets.
I agree with it with respect to that. We're on the same page, Your Honor. I agree with that with respect to that one argument. He didn't object to any of my other arguments, which they now object to. And you can't, for the first time on appeal, object to closing arguments that were not preserved at trial. That one argument they objected to. They preserved the issue on appeal. But this is the problem.
Let's make this as clear as possible. I asked Mr., and I hope I pronounce it, Mr. Hewer, thank you, sir. I asked Mr. Hewer if they were talking, the relevant universe was what is delineated at their brief at page 19, the 6 bullets.
Yeah, they didn't. They didn't.
And you are, and it seems to me that all of those were properly preserved for appeal, and I think you just agreed with that.
No. Let me say this, just so we're clear, Your Honor.
It strikes me that all of those are properly preserved pursuant to this objection, but
I respectfully disagree, and this is why. They object to 5 arguments. First argument, and they didn't object. They only objected to one of these 5 at the trial level. The first argument that they now object to on appeal for the first time is, now a review of the evidence proved the government hasn't been close to being fair to my clients. Nothing wrong with that argument. They did not object to that argument, so they have waived that argument.
I request the court give a corrective instruction that any notion of whether the government is fair to them plays no part in this case. That's part and parcel of their objection.
Well, he says what he was really zeroing in on, how does the government treat you? What's your common experience about how the government treats its citizens? Are they fair? Are they unfair? I suggest to you in this case, ladies and gentlemen, they could not have been unfair. That was the one argument they objected to. That's my point, Your Honor. But my real point is this. That isn't what this case is about. What this case is about is, and it was a 2-week trial, there were 13 witnesses. It was not the result of anything improper that I said. It was an eminent domain taking on March 8th, 2019. And the issue of the case was, what was the highest price that my client's property was worth in Somerville? Now, the evidence in the case was that our property was at the gateway to Somerville. It was between Kendall Square and Route 93. It was a perfect location. And the evidence was that laboratory use was packed at Kendall Square, and so it was moving out to Somerville. The evidence was also that there were the lowest interest rates of all time. There was huge demand for commercial property in Greater Boston, one of the hottest real estate markets anyone had ever seen. And the issue in this case, as we all know, was fair market value. Cobble Hill's position was that the highest and best use was a 200,000 square foot lab building. Somerville's position was that the highest and best use was a 340,000 square foot, 340 unit apartment site. So this is important for the court to understand. Both sides, they had an appraiser named Reensterner, we had an appraiser named Toner, and another fellow who was a broker who sold billions of dollars, like $30 billion worth of property in this area. They all testified. They all agreed that the buildings could be built. That really wasn't an issue, because if Somerville said the 340,000 square foot building could be built, obviously our 200,000 square foot building could be built. So the next thing they agreed upon was comparable sales was the approach that should be used. Each of the appraisers went out into the area and found comparable sales that they felt were helpful. Now, there were two comparable sales that they zeroed in on. 28 Fitchburg was what COBBLE zeroed in on, and the property at 20 Innerbelt was what Somerville zeroed in on. We took a 2 to 3 hour view. The jury got on a bus. They went and they looked at the property, and then they went and looked at the comparable sales. 28 Fitchburg was the perfect comparable sale in this case. It was about a quarter mile away. It was only 2 acres. Our property was 4 acres. It sold for $32,450,000, and that price was fixed on July 8th, 2019, and that was only 4 months after the taking date. So you have a sale that's a quarter of a mile away that sells for this huge amount of money, and the buyers want to use it for lab, and it was just the perfect comparable sale. Another thing that happened in the area there was a lot of evidence about is right next to my client's property is where the new MBTA station was. So obviously that was a huge positive. And it had, this sale at 28 Fitchburg had no permits. Now,
Counsel, you're running low, so I just want to ask you, do you agree that the jury came back with a verdict, the damage amount that was more than what you were requesting and more than any of your experts testified?
No, I do not agree with that. What happened was this, and to answer your question, no. The 28 Fitchburg sale, when you divide it by the square footage that was allowed there, and the evidence was that under the zoning they could have had 183,824 square feet. So what happened was the sale price, when you took it and divided it by that 183,324 square feet or whatever it was, it translated into $176.53 per buildable square foot. So just so you follow that, Your Honors, what real estate developers are interested in is how much can I build there? So what they thought when they signed that purchase and sale agreement for that huge amount of money is they thought they could build about 183,000. And one unit of comparison is you divide the purchase price by the square footage, and it comes to $176.53. When you multiply 200,000 times $176.53, you come down to a mathematical precision of the verdict in this case, $35,306,000. What the appraiser in our case did was he just rounded down to $176. But this jury which had 3 lawyers on it. The judge talked about the jury. It had 3 lawyers on it. It had a university librarian. It had scientists. It had an OBGYN doctor. He said, now that's a Middlesex County jury. And what they did after they listened to all of this evidence is they found the obvious. They found that 28 Fitchburg was the perfect comp, and they didn't even go to the rounding. They considered this. They deliberated for 10 hours over 2 days. They didn't just run
Going
back
just
to
a
the...
little bit more, elaborating just a tiny bit more than you need to for the answer that question, and you're over your time.
Oh, I'm sorry.
So that's no apology necessary. Both of the arguments have been excellent. We really appreciate it. The briefing was also excellent. I think that we have everything that we need to know to settle the case. The case was also tried very well, as far as I could tell from reading the transcript. So we appreciate your arguments, and always don't like to cut somebody off, but that's the rule.
Those are the rules,
That's
Your
the
Honor.
rule.
I understand. Thank you for your time.
All right. Thank you very much. The court will stand in recess.